हेलो एवरीवन, वेलकम टू द चैनल। यहाँ पे पॉलिटी सीरीज़ हम कर रहे हैं और उसमें फंडामेंटल राइट्स का फर्स्ट पार्ट कर चुके हैं। आज की क्लास फंडामेंटल राइट्स का पार्ट सेकंड है। क्वेश्चन नंबर 57, विच वन ऑफ द फॉलोइंग राइट्स इज अवेलेबल अंडर द आर्टिकल 19 सब क्लॉज 1D रेड विद आर्टिकल 21? राइट टू ट्रैवल अब्रॉड, राइट टू शेल्टर, राइट टू privacy, राइट टू information. In the Govind versus State of MP and ANR 1975 and Malak Singh and others versus State of Punjab and Haryana and others 1980, the Supreme Court held that the right to privacy is implicit under Article 21. This right is the right to be let alone. In the context of surveillance, it has been held that surveillance, if intrusive and seriously encroaches on the privacy of citizens, can infringe the freedom of movement guaranteed by Articles 19(1)(d) and Article 21. Right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Article 14 and the provisions under the 42nd Amendment to the Constitution, Article 17 and DPSP in Part 4, Article 21 and the freedoms guaranteed in Part 3, Article 24 and the provisions under the 44th Amendment of the Constitution. Justice K.S. Puttaswamy and others versus Union of India is a landmark judgment of the Supreme Court of India, which holds the right to privacy is protected as a fundamental right under Article 21 of the Constitution of India. Hence, option C is correct. Article 21 and the freedoms guaranteed in Part 3. Right to privacy is protected under which article of the Constitution of India? ये पिछले क्वेश्चन में आपने देखा. Which article of the Constitution of India safeguards one's right to marry the person of one's choice? Article 21. In Lata Singh versus State of UP 2006, the Supreme Court viewed the right to marry as a component of the right to life under Article 21 of the Indian Constitution. In the Hadia marriage case, the Supreme Court also said that the right to convert and choose a partner is implicit under Article 21 of the Constitution. Which one of the following does not fall within the purview of Article 21 of the Constitution? Medical aid to injure by a doctor, sexual harassment of women at workplace, pollution of the quality of water, or capital punishment. Article 21 of the Indian Constitution provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Honorable Supreme Court of India has widened the scope and orbit of the right to life and personal liberty on various occasions. According to the question given here, option D is correct, as from the decision of Bachchan Singh versus State of Punjab case, it is now clear that the provisions of the capital punishment as given in section 302 of IPC is not violative of Article 21 of the Constitution because it is given only for serious crimes. So capital punishment does not come under the provisions of Article 21 of the Constitution. All the other rights given in the options come under the right to life and personal liberty, as it has been declared by the Supreme Court through the following decisions: as medical aid to injured by doctor in Parmanand Katara versus Union of India 1989 Supreme Court case, sexual harassment of women at workplace in Vishakha versus State of Rajasthan 1997, pollution of the quality of air in Subhash Kumar versus State of Bihar in 1991. So यहाँ पे पूछा था does not fall within the purview of Article 21. तो इस explanation के according medical aid to injure by a doctor, sexual harassment of women at workplace, pollution of quality of water, ये तीनों में है, लेकिन capital punishment stays out of the purview of Article 21. Next question, which one of the following rights cannot be suspended or restricted even during national emergency? Right to reside and settle in any part of the country, right to life and personal liberty, right to move freely throughout the territory of India, right to carry on any profession or business. After the 44th Constitutional Amendment Act 1978, fundamental rights of life and personal liberty, that is Article 21, cannot be suspended even during national emergency. If the national emergency is declared on the grounds of war or external aggression, the fundamental rights under Article 19 are automatically suspended. It cannot be suspended on the grounds of armed rebellion. So Article 21 यहाँ पे हमने देखा that it cannot be suspended during national emergency. Article 21 says right to life and personal liberty. So option B is correct. The scope of Article 21 of the Constitution was expanded to include right to education because of the decision of Supreme Court in the case of Unni Krishnan versus Andhra Pradesh, Govind versus State of Madhya Pradesh, Parmanand Katara versus Union of India, Chameli Singh versus State of Uttar Pradesh. The Supreme Court in the case of Unni Krishnan and others versus State of Andhra Pradesh and others, 1993, organized in the form of a right-free education for children up to the age of 14 years. The court held that the citizens of the country have the fundamental right to education. This right comes out of Article 21. However, the right is not absolute. The content and measures of the right must be determined in light of Article 41 and 45. So आप कमेंट कर सकते हैं कि आर्टिकल 41 एंड 45 किसके अंतर्गत आता है, DPSP या फंडामेंटल ड्यूटीज. सो उन्नी कृष्णन वर्सेस आंध्र प्रदेश में यह हुआ था. राइट टू एजुकेशन टू ऑल चिल्ड्रन बिटवीन द एज ग्रुप ऑफ 6 to 14 years इज included in DPSP, a fundamental right, a statutory right, none of the above. The Constitution 86th Amendment Act 2002 inserted Article 21A in the Constitution of India to provide free and compulsory education to all children in the age group of 6 to 14 years as a fundamental right in such a manner as the state may by law determine. The right of children to free and compulsory education Act 2009 represents the legislation envisaged under Article 21A. The RTE Act came into effect on 1st April 2010. So इसमें कौन सा करेक्ट हो जाएगा? It's a fundamental right under Article 21A. When was the right to education added through the amendment in the Constitution of India? 1st April 2010. यहाँ पे आपने देखा ना, the RTE Act came into effect on 1st April 2010. Which one of the following is a human right as well as a fundamental right under the Constitution of India? Right to education, right to information, right to work, right to housing. So right to education is a human right as well as a fundamental right under the Constitution of India. Assertion: the state shall provide free and compulsory education to all children of the age group of 6 to 14 years. In a democratic society, right to education is indispensable in the interpretation of the right to development as a human right. According to Article 21A of the Indian Constitution, the state shall provide free and compulsory education to all children of the age of 6 to 14 years. Thus, A is true. Education is a fundamental human right and is indispensable in the interpretation of the right to development as a human right, as it promotes individual freedom and empowerment of children. Both are correct and R is the correct explanation of A. Next question, which of the following are envisaged by the right against exploitation in the Constitution of India? Prohibition of traffic in human beings and forced labor, abolition of untouchability, protection of the interests of minorities, prohibition of employment of children in factories and mines. The right against exploitation given in Articles 23 and 24 provides for two provisions, that is abolition of trafficking in human beings and begar, that is forced labor, and abolition of employment of children below the age of 14 years in the hazardous jobs like factories and mines, etc. So prohibition of human traffic in human beings, prohibition of traffic in human beings and forced labor, and prohibition of employment of children in factories and mines. So C is the correct answer. Which provision of the fundamental rights is directly related to the exploitation of children? तो आर्टिकल 23 एंड 24 ऊपर देखा आपने. आर्टिकल 24 में क्या था? Related to the right against exploitation of the children. This article prohibits the employment of children under the age of 14 years in any factory, mines or engagement in any other hazardous employment. Article 24 of the Constitution of India prohibits the employment of children in factories related to hazardous work. Such prohibition is absolute prohibition, partial prohibition, reasonable prohibition or moral prohibition. It's an absolute prohibition. As per Article 24, no child below the age of 14 years shall be employed to work in any factory or mine or engage in any other hazardous employment. Such prohibition is an absolute prohibition. Which of the following is not a part of the Article 20 of the Constitution of India? Double jeopardy clause, ex post facto law, prohibition against torture, prohibition against self-incrimination. Prohibition against torture is not a part of Article 20 of the Constitution of India. Protection from torture is a fundamental right enshrined under Article 21, life and liberty. Article 20 of the Indian Constitution provides protection in respect of conviction and offences. Conviction for offences. No person shall be convicted of any offence except for violation of the law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. No person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. इसमें ऑप्शन सी करेक्ट है. Which article under the fundamental rights is directly related to the exploitation of children? तो वो आपने ऊपर देखा ही था, आर्टिकल 24 कि 14 ईयर्स से अगर लेस देन 14 ईयर्स ऑफ एज है तो उन्हें माइंस, इंडस्ट्रीज एंड हजार्डस प्लेसेस पर एम्प्लॉय नहीं किया जाना है. Which one of the following articles of the Constitution deals with the fundamental rights related to the exploitation of children? So Article 24. Next is child rights are protected in the article of ICCPR. Article 24 of ICCPR, International Convention on Civil and Political Rights, protects child rights. It is worth mention that Article 24 of the Indian Constitution also protects child rights. So same article in both the places. Which article of the Constitution provides protection to the accused regarding conviction from double bar and self-incrimination? Article 20 subclause 2 says that no person shall be prosecuted and punished for the same offence more than once. While Article 20 subclause 3 describes that no person accused of any offence should be compelled to be a witness against himself. So Article 20. Next is an accused of any offence cannot be compelled to be a witness against himself. Which article of Indian Constitution provides for this? ऊपर देखा आपने 20 subclause 3. Article 20 has provided a safeguard to the persons accused of crimes. Article 20 subclause 3 of the Constitution says that no person accused of any offence shall be compelled to give witness against himself. That is self-incrimination. This is based on the legal presumption that the accused is innocent till his guilt is proved. Innocent until proven guilty. It is the duty of the prosecutor to establish his guilt. No person shall be prosecuted and punished for the same offence more than once. Under which article the above preservation of conviction for crime is given? ये आपने ऊपर देखा था, आप कमेंट भी कर सकते हैं. नेक्स्ट आर्टिकल, इसका एक्सप्लेनेशन देख लेते हैं. आर्टिकल 20 सबक्लॉज 2 of the Constitution of India says that no person shall be prosecuted and punished for the same offence more than once. This is called doctrine of double jeopardy. Doctrine of double jeopardy. The objective of this article is to avoid harassment which may be caused by successive criminal proceedings where the person has committed one crime. There is a law maxim related to this, nemo debet bis vexari. This means that no man shall be put twice in peril for the same offence. Which article gives safeguard to the fundamental rights of arrested persons? Article 22 of the Constitution mentions that no arrested person shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Which of the following is not correctly matched? Article 22.1, 22.4, point means subclause. So, according to them, Article 22, subclause 2 given, Parliament may by law prescribe the circumstance under which a person may be detained for a period longer than 3 months. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate. तो ये वाला केवल इनकरेक्ट है, बाकी सारे करेक्ट हैं. तो करेक्ट वाले देख लेते हैं. 22 सब क्लॉज 1 में क्या दिया है? राइट टू बी डिफेंडेड बाय अ लीगल प्रैक्टिशनर ऑफ हिज और हर चॉइस. आर्टिकल 22 सब क्लॉज 4, नो लॉ providing for preventive detention shall authorize the detention for a period longer than 3 months. Article 22 सब क्लॉज 1 ये सेम हो गया. No person who is arrested shall be in custody without being informed as soon as may be of the grounds for such arrest. ये I think गलत है क्या? आप लोग को पता है तो कमेंट कर सकते हैं नीचे कमेंट बॉक्स में, पर इनके अकॉर्डिंग थर्ड पार्ट करेक्ट है. Under the Preventive Detention Act, a person can be arrested without trial for 3 months. Article 24, subclause 4 of the Constitution of India says that no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months. Under preventive detention, a person can be detained without trial for period of 3 months. किस आर्टिकल में है? 24 subclause 4 of the Indian Constitution. A person can be detained without trial maximum for a period of 3 months under preventive detention. Okay, next question is, according to the Constitution of India, the central government has a duty to protect states from internal disturbances. The Constitution of India exempts the states from providing legal counsel to a person being held for preventive detention. ये तो नहीं है, ऊपर आपने पढ़ा ही एक्सप्लेनेशन, और जो भी संविधान में लिखा हुआ है वो सारे स्टेट्स पर भी एज इट इज़ लागू होता है. अकॉर्डिंग टू द प्रिवेंशन ऑफ टेररिज्म एक्ट 2002, कन्फेशन ऑफ द अक्यूज्ड बिफोर द पुलिस कैन नॉट बी यूज्ड एज एविडेंस. Let us see. Article 355 of the Indian Constitution provides that it shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions in this Constitution. Hence, statement 1 is correct. Has the duty to protect states from internal disturbances. सेंट्रल गवर्नमेंट की ड्यूटी है. आर्टिकल 22 ऑफ द कॉन्स्टिट्यूशन प्रोवाइड्स प्रोटेक्शन अगेंस्ट अरेस्ट एंड डिटेंशन इन सर्टन केसेस. क्लॉज 5 ऑफ दिस आर्टिकल सेज दैट व्हेन एनी पर्सन इज डिटेन्ड इन परसुएंस ऑफ एन ऑर्डर मेड अंडर एनी लॉ प्रोवाइडिंग फॉर प्रिवेंटिव डिटेंशन, the authority making the order shall, as soon as may be possible, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. Thus, Article 22, subclause 5 provides a legal opportunity to the detainee. Hence, Statement 2 is not correct. As per the Prevention of Terrorism Act, repealed, which was repealed in 2004, a confession made by a person before a police officer and recorded by that police officer either in writing or on any mechanical or electronic device shall be admissible in the trial of such person for an offence under this act. Hence 3 is also incorrect. इसमें ये बोल रहे थे कि इट कैन नॉट बी यूज बट एक्चुअली इट कैन बी यूज्ड, तो ये दोनों इनकरेक्ट और फर्स्ट करेक्ट, तो ओनली 1। और यहाँ से आपको ये इसका भी आंसर मिल गया जो ऊपर वाला ये था ना, नो पर्सन हु इज अरेस्टेड शैल बी इन कस्टडी विदाउट बीइंग इन्फॉर्म्ड एज सून एज मे बी ऑफ द ग्राउंड फॉर सच अरेस्ट। नेक्स्ट क्वेश्चन, with reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. Makes out a sufficient case. State governments have their own prisoners release on parole rules. Let's see, parole is the release of a prisoner either temporarily for a special purpose or completely before the expiry of a sentence on the promise of good behavior. Such a promise is known as word of honor provided in the parole order. Parole is not recognized as a right in India. Despite the fact that it has administrative importance, a prisoner's claim to parole is not absolute, and prison authorities have considerable discretion in granting parole to that prisoner. However, parole is considered a right for prisoners by a number of international accords and organizations. The grant of parole is governed by rules made under the Prison Act 1894 and Prison Act 1900. Many state governments have also formulated guidelines to bring out objectivity and facilitate decision making to determine whether parole needs to be granted in a particular case or not. Such decisions are taken in accordance with guidelines framed from time to time. The Prisons, Bombay Furlough and Parole Rules 1959 have been enacted by exercising rule-making power under Section 59 Subclause 5 of the Prisons Act 1984. Hence, statement 1 is wrong and 2 is correct. Next is the provision of right to freedom of religion includes freedom of propagation of religion, right to wear and carry kripans by Sikhs, states' right to make laws for social reforms, right to conversion of religion by people by religious bodies. Article 25 of the Constitution provides freedom of conscience and free profession, practice and propagation of religion, and also the right of the state to make any law for social reforms. Carrying and wearing of kripans by Sikhs is deemed as the right of freedom of religion by virtue of explanation 1 of Article 25. The right to conversion of religion by religious bodies or institutes is not provided under this article. So this one is not provided. 1, 2, 3 are correct. Under which article of the Indian Constitution wearing of kripans by Sikhs is deemed as a right to freedom of religion? Article 25. 25 of the Indian Constitution refers to freedom of religion. The word Hindu in the Article 25 of the Constitution of India does not include Buddhists, Jains, Parsis or Sikhs. So this does not include Parsis. According to Article 25, Hindus shall be construed as including persons professing the Sikh, Jain and Buddhist religion, but they do not include Parsis. According to Article 25 of the Constitution, right to freedom of religion is not subjected to public order, health, morality or humanism. According to Article 25 of the Indian Constitution, all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. But these rights have certain limitations imposed on the grounds of public order, morality and health. Humanism is not a limitation imposed under Article 25. What are the restrictions in the freedom to manage religious affairs in the Article 26 of the Constitution? Public order, national security, education, morality, health, or secularism. Every religious denomination or any of its sections shall have the right to establish and maintain an institution for religious and charitable purposes, manage its own affairs in matters of religion, own and acquire movable and immovable property, and administer such property in accordance with law. Rights under Article 26 are also subject to public order, morality, and health, but not subject to other restrictions related to fundamental rights. So, public order, morality, and health. So, it is 1, 4, and 5. Which one of the following is not correctly matched? Article 23, prohibition of traffic in human beings and forced labor. Correct. 24, prohibition of employment of children in factories. ये भी ऊपर आपने देखा. Correct. Article 26, freedom to manage religious affairs. ये भी देखा. Article 29, freedom of establishment and administration of educational institutions by minorities. Let us see. Freedom to establish and administer educational institutions by the minorities is given under Article 30, while 29 is related to the protection of the interest of minorities. So, जो इन्होंने ये लिखा तो ये आर्टिकल आइदर यहाँ पे 30 होना चाहिए या एक्सप्लेनेशन दूसरा होना चाहिए. So, this is not correctly matched. Which one of the following pairs is not correctly matched? Prohibition of traffic in human beings and forced labor, Article 23. Protection of interest of minorities, Article 29. ऊपर वाले एक्सप्लेनेशन में आपने देखा था Article 29 is related to the protection of interest of minorities. यहाँ पे राइट टू कॉन्स्टिट्यूशनल रेमेडीज आर्टिकल 32 होता है. राइट ऑफ माइनॉरिटीज टू स्टैब्लिश एंड एडमिनिस्टर एजुकेशनल इंस्टीट्यूशन, ये आर्टिकल 31 नहीं 30 में होता है. ये भी ऊपर यहाँ पे दिया था. फ्रीडम टू स्टैब्लिश एंड एडमिनिस्टर एजुकेशनल इंस्टीट्यूशन बाय द माइनॉरिटीज इज गिवन अंडर आर्टिकल 30. The right of minorities to establish and administer educational institutions is provided under Article 30, while Article 31 was for compulsory acquisition of property, which has been repealed by the 44th Constitutional Amendment Act 1978. And now the right to property is a legal right under Article 300A in Part 12th of the Constitution. Which article of the Constitution protects the right of minorities to establish and administer educational institutions of their choice? So ये ऊपर आपने देखा Article 30. Article 19 is right to freedom. 26 is freedom to manage religious affairs. 29 is protection of interest of minority community. And Article 30 is right of minorities to establish and administer educational institutions. Under which of the following articles of the Indian Constitution it has been provided that all minorities shall have the right to establish and administer educational institutions of their choice? Again, it is the same question. Question number 94. Assertion. Article 30 of the Constitution of India does not define the term minorities. The Constitution recognizes only linguistic and religious minorities. Article 30 of the Indian Constitution provides for the right of minorities to establish and administer educational institutions. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. 30. Subclause 1. According to Article 30, Subclause 2, the state shall not, in granting aid to educational institutions, discriminate against any educational institution on the grounds that it is under the management of a minority community, whether based on religion or language. So it is clear that minority is not defined in this article, hence both statements are correct, but reason does not explain assertion. The Constitution of India recognizes only religious minorities, only linguistic minorities, religious and linguistic minorities. ऊपर आपने देखा. Constitution of India recognizes both religious and linguistic minorities. According to Article 29, citizens residing in the territory of India have a distinct language, script or culture of its own, shall have the right to conserve the same. Article 30 provides minorities the right to establish and administer educational institution, whether based on religion or language. Which of the following is given the power to enforce the fundamental rights by the Constitution? All courts in India, the Parliament, the President, the Supreme Court and High Courts. Article 13 of the Constitution grants the power of judicial review to the Supreme Court and High Courts in the case of violation of fundamental rights. The Supreme Court under Article 32 and High Court under Article 226, in exercising their power, may declare any law or enactment passed by the legislature void or unconstitutional on the ground of contravention to the fundamental rights. The guardian of the fundamental rights is judiciary. The Constitution of India has assigned judiciary, that is the Supreme Court of India and the High Courts, the responsibility of the protection of fundamental rights. The most significant of fundamental rights is the exclusive right to the constitutional remedies under Article 32 and 226 of the Constitution of India. Under the Indian Constitution, who is the guardian of fundamental rights? It is the same question. गिवन ऑप्शंस में से सिर्फ सुप्रीम कोर्ट है. अगर हाई कोर्ट भी होता तो फिर जुडिशरी पर जाते, सिर्फ ओनली सुप्रीम कोर्ट नहीं. अंडर द इंडियन कॉन्स्टिट्यूशन, हु अमंगस्ट द फॉलोइंग इज कंसिडर्ड टू बी द गार्डियन ऑफ द फंडामेंटल राइट्स? इट इज जुडिशरी. Which one of the following is regarded as a protector of fundamental rights of citizens and guardian of the Constitution of India? Parliament, Attorney General, the Supreme Court or the President? It is the Supreme Court. The Supreme Court of India is a protector of the fundamental rights of citizens and guardian of the Constitution of India because through the right to constitutional remedies, Article 32, it protects the fundamental rights of citizens. Besides, it interprets as well as enforces the provisions of the Constitution. Which of the following statements is not correct? K.M. Munshi was one of the members of the drafting committee of the Constitution. ये पिछले lectures में आपने देखा है. The Constitution of India was adopted by the Constituent Assembly. The Panchayati Raj was recommended by the Balwant Rai Mehta Committee Report 1957. The President of India is the guardian of fundamental rights under the Constitution. नहीं. Judiciary is. All the given statements are correct except D. As the judiciary, the Supreme Court and the High Courts is the guardian of the fundamental rights, not the President of India. Which of the following rights can be enforced under Article 32 of the Indian Constitution? Constitutional rights, fundamental rights, statutory rights, all of the above. So, fundamental rights. Article 32 of the Constitution provides constitutional remedies against the violation or transgression of fundamental rights conferred by Part 3. Supreme Court shall have the power to issue directions or orders or writs, including writs like habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by Part 3. That is why the Supreme Court has been called as the guardian of the fundamental rights. Which one of the following rights was described by Dr. B.R. Ambedkar as the heart and soul of the Constitution? ये हम पहले भी देख चुके हैं. Article 32. Right to constitutional remedies, which is Article 32. Dr. Bhim Rao Ramji Ambedkar described Article 32 as the heart and soul of the Indian Constitution. In his words, if I was asked to name any particular article in this Constitution as the most important, an article without which the Constitution would be nullity, I would not refer to any other article except Article 32. It is the very soul of the Constitution and the heart of it. It is also notable that on various occasions the preamble to the Constitution is also recognized as the soul of the Constitution, but according to Dr. Ambedkar, Article 32 is the heart and soul of the Constitution. Consider the following statements. Dr. Ambedkar has described Article 32 of the Constitution as the very soul of it. Article 32 provides an effective remedy against the violation of fundamental rights. Yes, both are true and this explains assertion. Dr. Ambedkar has described Article 32 as the very soul and heart of the Constitution, as Article 32 provides an effective remedy against the violation of the fundamental rights enshrined in the Indian Constitution. The Supreme Court has the power to issue directions, orders or writs for the enforcement of any fundamental rights. Thus, A and R both are true and R is the correct explanation of A. Consider the following statements concerning the powers of the Supreme Court to issue certain writs to stop violation of fundamental rights. Supreme Court has the power to issue writs like habeas corpus, mandamus, prohibition, quo warranto and certiorari, which is appropriate for the enforcement of fundamental rights. Correct. Parliament may by law empower any other court. Parliament may by law empower any other court to exercise within its jurisdiction the powers given to the Supreme Court. Yes, Parliament can do that. So both are correct. Article 32, subclause 2 of the Constitution gives an exclusive original jurisdiction to the Supreme Court in regard to the enforcement of fundamental rights. It is empowered to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, to enforce them. As per Article 32, subclause 3, without prejudice to the powers conferred on the Supreme Court by clause 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. Hence both statements are correct and option D is the correct answer. Under which of the following article of the Constitution of India the Supreme Court is empowered to issue different writs for the enforcement of fundamental rights of the citizens? So Article 32 of the Constitution of India empowered the Supreme Court to issue different writs for the enforcement of fundamental rights of citizens. These writs are habeas corpus, mandamus, prohibition, certiorari and quo warranto. Article 226 empowers a high court to issue these 5 writs for the enforcement of fundamental rights and for any other purpose. ये याद रखिएगा. Which one of the following writs is regarded as the greatest safeguard for the liberty of a person? Mandamus, habeas corpus, certiorari or prohibition? Writ of habeas corpus is regarded as the greatest safeguard of the liberty of a person. It calls upon the person who has detained another to produce the latter before the court, to let the court know on what grounds he has been confined and to set him free if there is no legal justification for the imprisonment. ज़बरदस्ती किसी को अगर डिटेन किया है तो जिसने डिटेन किया है वो अथॉरिटी कोर्ट के सामने प्रस्तुत होगी और कोर्ट को एक्सप्लेनेशन देगी कि क्यों उन्होंने डिटेन किया है. अगर कोई प्रॉपर जस्टिफिकेशन नहीं होगा तो जिसे डिटेन किया गया था दैट मैन और वुमन विल बी सेट फ्री और दैट पर्सन विल बी सेट फ्री. Which one of the following writs can be issued by a high court to secure the liberty of the individual? Mandamus, habeas corpus, quo warranto or prohibition? Article 226 of the Indian Constitution provides for the power of the High Courts to issue certain writs. To secure the liberty of the individual, the High Court can issue a writ of habeas corpus. The writ is issued by the court whose object is to secure the release of a person found to be detained illegally and secure the liberty of the individual. Supreme Court has also has the power to issue writs under Article 32 of the Indian Constitution for the rights enumerated in Part 3 of the Constitution, fundamental rights, whereas the High Court can issue writs related to legal rights also. So इसका आंसर habeas corpus. Same question almost था ऊपर से. The writ which may be filed for protection of right to personal freedom is, ये भी same question है, habeas corpus. Match. Habeas corpus, be more fully informed by which authority we command let us have the body, and writ to subordinate courts. Mandamus, prohibition, certiorari and quo warranto. ये आपने ऊपर देखा था फर्स्ट लेक्चर में. So habeas corpus, let us have the body. Mandamus, we command. Prohibition, writ to subordinate courts. Certiorari, be more fully informed. Quo warranto, by which authority? Which of the following is not correctly matched? Habeas corpus, to have body of. Mandamus, we command. Prohibition, to be certified. No, it is certiorari. Quo warranto, by what authority? So not correctly matched is C option. Which one of the following constitutional remedies is also known as post-mortem? In the certiorari writ, Supreme Court and the High Court could re-examine the decision given by the subordinate courts. Through the quo warranto writ, the court inquires into the legality of a claim of a person to a public office. This writ prevents the illegal assumption of a public office by an individual. Therefore, both the writs have a sense of post-mortem. Thus, appropriate answer for this would be E. But BPSC considered C as the correct answer. सो BPSC के हिसाब से सर्शोरारी करेक्ट है, बट क्यो वारंटो भी है जो कि पोस्टमार्टम रिट की तरह जानी जाती है। सो इसलिए इनके अकॉर्डिंग ई इज द करेक्ट आंसर। In which petition judiciary orders executives to perform their duty through mandamus, a writ of mandamus, which means we command in Latin, or sometimes mandate in the name of one of the prerogative writs in the common law. It is issued by a superior court to compel a lower court or a government officer to perform mandatory or purely ministerial duties correctly. When the Supreme Court issued a writ to a person or to an institution to perform its duty, it is called mandamus. Now यहाँ पे आपको ये articles को match करना है इससे. Cultural and educational rights, right to constitutional remedies, right against exploitation, and right to equality. तो सबसे पहले आप देखते हैं राइट टू इक्वालिटी 14 to 18 आर्टिकल होता है. फिर राइट अगेंस्ट एक्सप्लॉयटेशन आर्टिकल 23 and 24 होता है, एक ट्रैफिकिंग और एक अगेंस्ट चाइल्ड लेबर. देन कॉन्स्टिट्यूशनल रेमेडीज इज आर्टिकल 32, ये आपने अभी ऊपर देखा. कल्चरल एंड एजुकेशनल राइट्स इज आर्टिकल्स 29 and 30. Question number 119, match. Fundamental duties. Parliament can amend fundamental rights. Doctrine of basic structure. Prohibition of trafficking in human beings. Minerva Mills case, Article 23, 42nd Amendment of the Constitution, and Keshwanand Bharti case. So, fundamental duties by 42nd Amendment of the Constitution. Parliament can amend fundamental rights. That was prescribed in Keshwanand Bharti case. Doctrine of basic structure in Minerva Mills case. Prohibition of trafficking in human beings, Article 23 of the Constitution. By which of the following case Parliament got the right to amend fundamental rights? The first time the Supreme Court held that fundamental rights are amendable was in the case of Shankari Prasad versus Union of India and Sajjan Singh versus Rajasthan State in 1965. In the Golaknath case, the prior decision was reversed and it was held that amendment in fundamental rights is not possible. Again, in Keshwanand Bharti case in 1973, Supreme Court held that the amendment power of the Parliament is wide enough but not unlimited. It may amend fundamental rights but not in such way so as to destroy the basic structure of the Constitution. This case outlined the power of the Parliament to amend the fundamental rights without destroying the basic structure of the Constitution. The Supreme Court of India has propounded the doctrine of basic structure of the Constitution in which of the following case? The doctrine of basic structure of the Constitution owes its evolution to the majority judgment of the Supreme Court in the landmark case of Keshwanand Bharti versus State of Kerala 1973, which was approved by Minerva Mills versus Union of India case in 1980. Which one of the following cases outlined the basic structure doctrine of the Indian Constitution? So it's Keshwanand Bharti versus State of Kerala. Which of the following statements are incorrect? Part 3 of the fundamental rights of the Constitution is based upon Bill of Rights of the USA. Right to die is a fundamental right under Article 21 of the Constitution. Indian Constitution is a complete federal constitution. No, it is quasi-federal, not complete federal. Fundamental rights can be removed under the Indian Constitution. No, it's a part of basic structure. It cannot be removed. So, in philosophical and conceptual sense, the fundamental rights of the Indian Constitution similar to Bill of Rights of the USA. Significantly, right to die is not the fundamental right under Article 25 of the Constitution. यहाँ पे 21 है, यहाँ 25. Notably, यहाँ 21 होना चाहिए. The Indian Constitution is not a complete federal constitution but quasi-federal. According to the law established by the Apex Court of India, fundamental right can be amended but not removed because it comes under the basic structure of the Indian Constitution. Select the correct chronological order of the following judgments dealing with fundamental rights. Correct chronological order. Okay. D. A. Gopalan versus State of Madras in 1950. Golaknath versus State of Punjab in 67. Keshwanand Bharti versus State of Kerala in 73. Minerva Mills in 1980. तो ये दोनों तो आपने अभी ऊपर ही देखे थे. गोलकनाथ भी पिछले चैप्टर्स में देखा था. बस A. गोपालन वर्सेस स्टेट ऑफ मद्रास इन 1950. नेक्स्ट, what is the position of the right to property in India? Legal right available to citizens only, legal right available to any person, fundamental right तो नहीं है, neither fundamental nor legal ये भी नहीं है. legal right है but सिर्फ citizens को है या सबको है. As the constitution was originally drafted, the right to property was enshrined as the fundamental right. However, by the 44th Amendment Act 1978 of the Constitution, right to property was removed as a fundamental right and a new provision was added to the Constitution, that is Article 300A. Now it is a legal right. So it is available to any person. Right of property belongs to which category amongst the following? It's a legal right. Right to property is a legal right and statutory right. इनके हिसाब से दोनों करेक्ट हैं. It is a legal right. Okay. Read the following statements and select the correct option. Right to property was deleted from the list of fundamental rights by 44th Amendment Act of 1978. Yes. Right to property was made a legal right under Article 300A in Part 12 of the Constitution. ये भी आपने देखा. Yes. तो दोनों करेक्ट हो गए. Statement 1 and 2 both are true. At present, right to property under the Constitution of India is a legal right. Consider the following statements. Article 301 is related to right to property. No. 300A. Right to property is a legal right but not a fundamental right. Yes. Article 300A was inserted in the Indian Constitution by 44th Amendment during the period of Congress government. नहीं. कांग्रेस गवर्नमेंट नहीं थी. कौन सी गवर्नमेंट थी आप कमेंट कर सकते हैं. आर्टिकल 301 इज रिलेटेड टू फ्रीडम ऑफ ट्रेड, कॉमर्स एंड इंटरकोर्स एंड नॉट टू राइट टू प्रॉपर्टी. राइट टू प्रॉपर्टी वाज अ फंडामेंटल राइट अंडर आर्टिकल 19(1)(f) but by 44th Amendment 1978 this clause has been omitted and Article 300A has been inserted, which provides that no person shall be deprived of his property save by authority of law. This amendment was done at the time of Janata Party government. After that amendment, the right to property became a legal right and ceased to be a fundamental right. Thus, only statement 2 is correct. चलिए आपको आंसर भी मिल गया यहीं पर, जो मैं आपसे कमेंट में लिखने के लिए पूछ रही थी. आप फिर भी लिख सकते हैं. नाउ यू नो द आंसर. By which of the following right to property has been omitted? 44th Amendment Act of 1978. When was fundamental right to property abolished? Which of the following amendment act of the Constitution deleted the right to property from the list of fundamental rights? All these are same questions, इसलिए बहुत ज़्यादा मैं नहीं बता रही हूँ. By which amendment the right to property was abolished? 44th. The 44th Amendment to the Constitution of India removed the following right from the category of fundamental rights. Right to property. The right to property deleted from the list of fundamental rights guaranteed to the citizen of India by 42nd, 43rd, 44th. Which one of the following is not a fundamental right? Right to property. Which one of the following is not a fundamental right? Same question. Right to property. Which one of the following is not among the 6 fundamental rights provided by the Constitution of India? Right to protest, right to equality, right against exploitation, right to freedom of religion. Right to protest या यहाँ पे right to property लिखना चाह रहे होंगे. Among the 6 fundamental rights. The Indian Constitution does not grant which of the following rights? Right of equal shelter, right to equality, right to freedom of religion, right to liberty. So equal shelter ये कहीं पे भी नहीं mentioned है. Right of equal shelter. Indian Constitution gives right to equality. Article 14 to 18, right to freedom of religion 25 to 28, right to liberty 19 to 22, but does not provide the right to equal shelter. Which of the following is not a fundamental right granted by the Indian Constitution to its citizens? Right to settle in any part of the country है. Right to gender equality, yes. Right to information, ये एक फंडामेंटल राइट नहीं है, ये एक स्टैचुटरी राइट है, आरटीआई एक्ट. Right against exploitation, this is also a fundamental right. According to the decision of the Supreme Court, right to information lies in the right to freedom of speech and expression under Article 19(1)(a) of the Constitution of India, although it is not mentioned in the Constitution of India. Okay. No one can be compelled to sing the national anthem, since it will be violation of the right to freedom of speech and expression. Yes, it will be violation of the right to freedom of conscience and practice and propagation of religion. Yes, there is no legal provision obliging anyone to sing the national anthem. Yes. Supreme Court overruled the decision of High Court pronounced in the case of Bijoy Emmanuel versus State of Kerala. Court held that expelling the children based on their conscientiously held religious faith violated the Constitution of India as enshrined in Article 19(1)(a) and 25(1). Court said that no provision of law obliges anyone to sing national anthem. Choose the fundamental rights available to Indian citizens but not to aliens. Not to aliens. Freedom of speech and expression, equality before the law, right of minorities, protection of life and liberty. Right to freedom of speech and expression under Article 19 and the cultural and educational rights of minorities under Article 29 are available to Indian citizens only. They are not available to aliens. So, speech and expression and right of minorities. Which of the following fundamental rights is not available to foreign citizens? Equality before law, right to freedom of expression, ये ऊपर देखा ना आपने, speech and expression, this is only for citizens. Right to freedom of life and liberty, right against exploitation. So this is not available to foreign citizens. Under the Constitution, there are various fundamental rights which have been given to both citizens and non-citizens equally. These are equality before law, protection in respect of conviction for offence, protection of life and liberty, right to education, right against exploitation, right to freedom of religion. Whereas the provision related to Article 19(1)(a), freedom of speech and expression, is available only to citizens of India. Which one of the following rights is available to all persons under the Indian Constitution? Right to equal protection of law, right against discrimination, right to freedom of speech and expression, cultural and educational rights. Equality before law or equal protection of the laws is guaranteed by Article 14, which is given to all persons under the Indian Constitution, but the right against discrimination 15(16), right to freedom of speech and expression 19(1)(a), and the cultural and educational rights 29 and 30 are available only to the citizens of India. कौन कौन से अवेलेबल हो गए सिटीजन्स ऑफ इंडिया को? 15, 16, 19 सब क्लॉज 1A, 29 एंड 30. ये सारे राइट्स ओनली सिटीजन्स को अवेलेबल है. नेक्स्ट, विच ऑफ द फॉलोइंग राइट्स आर नॉट अवेलेबल टू ऑल पर्सन्स इन इंडिया? इक्वालिटी बिफोर द लॉ, ये आपने ऊपर देखा, आर्टिकल 14 इज अवेलेबल टू एवरीवन. राइट अगेंस्ट डिस्क्रिमिनेशन, ये अवेलेबल सबको नहीं है. फ्रीडम टू मूव फ्रीली थ्रू आउट द कंट्री, ये भी सबको अवेलेबल नहीं है. राइट टू कॉन्टेस्ट इलेक्शन, फॉरेनर्स कैन नॉट कॉन्टेस्ट इलेक्शन. सो right to equality before law is available to every person in India, but right against discrimination 15, 16, 17, the right to move freely throughout the territory of India 19(1)(d), and the right to contest election are available only to the citizens of India. So यहाँ पे जो हमने किया था इसमें एक अनटचेबिलिटी वाला जो है 17 वो भी ऐड कर लीजिए. इट इज़ अवेलेबल ओनली टू citizens of India. तो 15, 16, 17, 19 सब क्लॉज 1A, 29, 30 ये सारे राइट्स सिटीजन्स को अवेलेबल हैं. नेक्स्ट, which of the following rights conferred by the Constitution of India is also available to non-citizens? Right to constitutional remedies, freedom of speech, to move and settle in any part, freedom to acquire property. ये तीनों सिर्फ citizens को हैं, ये वाला non-citizen. Right to constitutional remedies is available to both citizens of India and non-citizens. But right to freedom of speech, freely travel throughout the country and to acquire property is given only to the citizens of India. A British citizen staying in India cannot claim right to freedom of trade and profession, equality before the law, protection of life and personal liberty, and freedom of religion. तो ये तो फ्रीडम ऑफ रिलीजन आपका आर्टिकल 25 to 28, प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी 21, इक्वालिटी बिफोर लॉ आर्टिकल 14, फ्रीडम ऑफ ट्रेड एंड प्रोफेशन ये है जो कि ब्रिटिश सिटीजन कैन नॉट क्लेम. A British citizen staying in India cannot claim right to freedom of trade and profession because the right which has been provided under Article 19(1)(g) is available only to the citizens of India. But other three rights given in the options are available to every person. So 19(1)(a) के साथ आपको पता चल गया कि 19(1)(g) is also available only to citizens. In India, if a religious sect or community is given the status of a national minority, what special advantages is it entitled to? It can establish and administer exclusive educational institutions. Yes. President of India automatically nominates a representative of the community in Lok Sabha. ऐसा कोई provision नहीं है. It can derive benefits from the Prime Minister's 15-point program. Let us see. No special representation for minorities is given under the Constitution. The statement 2 is wrong while the other two are correct. So it can derive benefits from the Prime Minister's 15-point program. This is also correct. So option C is correct. Bonded labor was abolished in India by the Act of Parliament enacted in the year 1976. Article 23, subclause 1 of the Constitution prohibits the traffic in human beings and forced labor. Any contravention in this provision shall be an offence punishable in accordance with law. Bonded labor system abolition ordinance 1975 was promulgated by the President on 25th October 1975 to replace the said ordinance. The Bonded Labor System Abolition Bill 1976 was introduced in the Parliament. Bonded Labor System Abolition Bill 1976 was passed by both the Houses of Parliament and it became an act in 1976. The child labor was prohibited in hazardous employment by Indian Constitution, judgment of Supreme Court on 10 December 1996 and United Nations Charter. Indian Constitution under Article 24 says that no child under the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. United Nations Charter has proclaimed that childhood is entitled to special assistance for the full and harmonious development of a child and his or her personality should grow up in a healthy environment. On December 10, 1996, in the case of MC Mehta versus State of Tamil Nadu, the Supreme Court held that the employment of children below the age of 14 years into hazardous child labor is unconstitutional and hence prohibited it. Fill in the blanks. Dash without duties are like men without shadows. So rights without duties are like men without shadows. Sir Ernest Barker has said rights without duties are like men without shadow. In the context of India, which one of the following is a correct relationship between rights and duties? Rights are correlative with duties. ये ऊपर आपने देखा सर अर्नेस्ट बार्कर के कथन से. Rights are personal and hence independent of society and duties. Rights, not duties, are important for the advancement of the personality of the citizen. Duties, not rights, are important for the stability of the state. In the context of India, rights and duties are correlative. According to Holland, every right implies the active or passive forbearance by others of the wishes of the party having the right. The forbearance on the part of others is called a duty. Rights and duties are two faces of the same thing. The Supreme Court has observed that there may be a rule which imposes an obligation on an individual or authority, and yet it may not be enforceable in a court of law, and therefore not give rise to the corresponding enforceable right in another person, but it would still be a legal rule because it prescribes a norm of conduct to be followed by such individual or authority. Thus, rights and duties are correlative and they give the effect to each other. Which one of the following statements is correct? Rights are claims of the state against the citizens? No, citizens against the state. Rights are privileges which are incorporated in the constitution of a state. Are they privileges which are incorporated in the constitution of a state? Rights are claims of citizens against the state. Yes. Rights are privileges of a few citizens against the many. No. Rights are essential for the complete development of human beings. The importance of rights has expanded immensely and has given birth to the concepts of fundamental rights, human rights, etc. Rights impose restriction on the powers of the state. These are a guarantee against state action. Thus, rights are claims of the citizens against the state. Concept of right to service originated in USA, Switzerland, Great Britain or China. Concept of right to service originated in Great Britain, UK. Right to service refers to laws which guarantee time-bound delivery of services for various public services rendered by the government to citizens. The right of citizens for time-bound delivery of goods and services and redressal of their grievances, Bill 2011, was an attempt to start such a law in India. However, it could not be passed. Notably, Madhya Pradesh is the first state in the country to implement the Right to Services Act on 25th September 2010. Bihar is the second state to implement such law on 15th August 2011. So यहाँ पर ये फंडामेंटल राइट्स वाला आपका चैप्टर फिनिश होता है। और आपको वीडियो कैसा लगा कमेंट में बताइए। अगर आपकी कोई भी क्वेरीज या डाउट्स हैं तो आप वो भी नीचे कमेंट में लिख सकते हैं। Thank you so much for watching this video. Next video will be on directive principles of state policy.